I'm Dr. Alan Blotcky. I'm a clinical and forensic psychologist in private practice in Birmingham, Alabama. Yay. And you can tell by my gray hair that I've worked in this area a long time, 41 years to be exact. And I would say for the past 15 years or so, I've concentrated on divorce and child custody and high conflict custody cases. And when you do that, you quickly realize that parental alienation is a real thing. It does happen, and that it is a problem in the court system in trying to explain to the court what parental alienation is. I would say since COVID, I've testified in close to 70 cases in 19 or 20 states. So what I'm going to be talking about today is really from my own experience and the experience of others, and to try to give you some perspective or at least context for being an expert in these kinds of cases. I think it's almost axiomatic to say that all cases of moderate and severe parental alienation will have a court case, because one way or another, it's going to get to court. And the reason for that is that moderate and severe parental alienation is not going to resolve on its own, despite all the good intentions of all the therapists involved. It's likely to stalemate. And progress is going to be stopped for a variety of reasons. And the variety of reasons really is that each of the parties involved in a parental alienation situation have different motivations and different intents. The alienating parent wants the alienation to keep going. The alienated child wants to remain aligned with the favored parent because it's where things have gotten. And the rejected parent is feeling miserable because there is no progress, and the rejected parent is not having contact or having limited contact with their child. So that's why we say family therapy oftentimes doesn't work, especially on its own, because it takes therapeutic intervention and court intervention in concert to make a difference. One without the other is helpful, but is not sufficient. And so that's where experts come in my view. Experts are important because they can provide education, information, and guidance to the court. That is your mantra, and you have to keep that in the back of your mind the entire time because that's your goal. Your goal is a one-person audience, which is the judge, because they're the ones who make the decisions. Educate, inform, and guide. And keep that in your head no matter what your role is as an expert. That's your job. And if you keep that in mind, I think it will be less frustrating and more clear-cut about what your job is, essentially, as an expert. So I'm going to talk about 4 different scenarios. And there are more, but I'm going to focus on 4 different scenarios of expert involvement. And they are, the first one is the obvious one, which is as a court-appointed custody evaluator. That's really kind of the easiest, not necessarily easiest, but the best way to be an expert, because you are going to get to see both parents, all the children, all the collateral information, all the reports, all the pleadings, all the documents. It's the best way to be thrown in to the middle and see everything. And so it puts you in a unique position to be an evaluator and also as an expert in that role. The second way is what I call a blind consultant for the court, which is where you are essentially blind to the specifics of the case, but you are asked to come into court and to educate the court about parental alienation in general. And so that's your opportunity to do that. You come in as the expert to talk about parental alienation, the basic principles, the basic tenets, the basic definitions, all of the stuff that we know, and you provide that. The third way we're going to talk about is as a consultant retained by the rejected parent's attorney to help that attorney navigate the case behind the scenes. In other words, you're not going to testify in court, but you're going to be an expert to help that attorney navigate the case. Okay? And then the fourth way we're going to talk about, the fourth scenario, is where a rejected parent, in concert with the attorney, retains you to come in and testify as best you can to the specifics of the case. So those are the four different scenarios that we're going to talk about. Now let me just say this off. There are a few things I want to say off the bat before we get into it. One is, to be an expert, you need to have the knowledge, because otherwise you're going to get bashed in court, and it's going to be painful. Okay, so you need the knowledge. You need to know the characteristics and all the tenets and definitions of parental alienation. You need to understand the counterintuitive nature of PA in many respects. It helps if you've done many, at least some, if not many, custody evaluations. It helps if you've done some or many testimonies. You need to have testified in court before. It helps if you've published papers in the field. It helps if you've presented papers at national or international conferences like this. It helps if you belong to relevant organizations like PASG. So it helps to have the knowledge and these credentials, essentially, to represent yourself as an expert, or else you're going to get bashed, because opposing attorneys will jump on it big time. So you have to have the gravitas, as best you can, to be an expert. The second thing I want to say is that to be a PA expert is not for the faint-hearted, right? Those of you who have done it are laughing because it's the truth. You are going to be subjected to personal and professional attacks, because that's what they see as their job. You're there as an expert, and at least one of the attorneys, if not more, are there to undermine you any way they can, and they will. So it's not for the faint-hearted, and you will learn that as you do it, that being attacked is commonplace. It's just the way it is. And you have to have thick skin, and you have to stay focused, and you have to stay calm, and you have to stay collected, and you have to keep on message as best you can, because they want you to get off message. That's their goal. Excuse me. The last thing I want to say before we get into it is, as an expert, success in a case is really not all or none, okay? And if you think it's all or none, you're setting yourself up for disappointment in many respects, because it's just not. I've gotten to the point now where I tell people success for me would be if you're having more contact with your child afterwards than you were having before. That's success. Now, that may not match a parent's idea of what success is, and that's why you have to have that conversation, because it helps if you're both on the same page and you have the same understanding of what success might look like. But if you go into it with the idea that it's all or none, you're going to be disappointed a lot of the time. And so I think you're better off to think of progress as baby steps, sometimes bigger than baby steps, but it's not going to be all or none. So sort of get that out of your mind and help your parent understand that, whoever you're there as an advocate for. So this first slide, we've kind of talked about it. Virtually all cases of moderate and severe PA will involve court proceedings. That's absolutely true. Mental health experts can make a difference. The goal of the expert is to educate, inform, and guide. Number 4 is my attempt to say these are the things that you need to keep in mind when you're talking about parental alienation in general or specifically. Talk about the definition. Focus on the 17 alienating behaviors because it's based on science. Talk about the 8 characteristics of an alienated child because it's based on science. Discuss the 5-factor model of diagnosis and how it's been validated in science. Talk about the 3 levels of severity. Talk about the PA-specific treatment protocols, or at least treatment guidelines that we have depending on the severity of the case. Talk about the uses and misuses of reunification therapy. Talk about the steps and missteps of GALs. We could spend a whole hour on that. Talk about how PA impacts children and teenagers now and in the future. So those are the sort of core important things to keep in mind as an expert as your guiding mantra in these cases. That's your Bible in a sense. That's your official synopsis in a sense. Keep that in mind as you go forward. Let's see if this clicker really works. It does. Okay, so let's talk about court-appointed custody evaluator. And what I've outlined on this overhead is that there's some advantages and some disadvantages or roadblocks. The advantages is you get to evaluate all family members. Like I said, both parents, all the kids, and that's sort of the ideal way to go. You want to have access to everybody, right? Because you need all of that information to put together. That you can obtain psychological testing with everybody, especially the parents, but even the kids, depending on their age and the situation. That you will have access to tons of collateral information, as much as you want, honestly. Every email, every text message, every recording, every picture, whatever documentation parents will have, you have access to that if you want it. Since it is court-appointed, you have the ear of the judge. A lot of times, if not most of the time, judges rely on these custody evaluations, and they will use them at the top of their list in terms of their decision-making. Since all family members are seen, there's little chance that you will be viewed as biased, although that's not entirely true. But in a general way, if you're seeing everybody, they can't claim that you're being biased because you didn't see mom, or you didn't see dad, or you didn't see the kids. And then last, since all family members are seen, maybe the GAL will listen to what your evaluation provides. That's a little bit wishful thinking, but sometimes it happens. A lot of times GALs make up their decision. They don't really listen to you, but hopefully they will, since the custody evaluation is the most comprehensive way that an expert can provide information on a case. So let's talk about some of the roadblocks. A custody evaluation is a huge undertaking because it does take a great amount of time and it's hugely expensive. Not everybody can afford it. Not everybody wants to take the time to do it. And not all judges will order it. So, but it is a major undertaking. It's not just something that can happen in a week or two. It takes months and it takes thousands of dollars. So it's prohibitive. Requires an ability to sift through mountains of information and to arrive at correct conclusions. Like I said, you can have mountains of information, that's for sure. You can have text messages and emails and recordings out the wazoo as much as you want, and all of that stuff you can sift through to try to cull out what's the important part. Third, you provide a written report that is easily digested by all the parties in the case. That's not always so easy. You know, writing a good report is science and art. It's a skill. It's not easy, you know. I've seen custody evaluations, literally, that were 215 pages long. And if you flip to the very end of it, it'll say, after all this, I'm not exactly sure what's going on. So, I've never written a 215-page report, and I always try to come to the right conclusions with the right recommendations, but okay. Must be able to testify about conclusions and recommendations in a clear, direct, and confident manner. That's true of any time you're there as an expert. You need to be clear, calm, confident, and present what you have to say in that way. The last one, it's harmful to a case if the custody evaluator's conclusions and recommendations are wrong or if the evaluator is inconclusive or wishy-washy. So I always say a custody evaluation is only as good as the evaluator, you know? And I've seen some fantastic custody evaluations, and I've seen some really bad custody evaluations. Because if you're not knowledgeable about PA and high conflict custody and childhood development and family dynamics, if you don't have the requisite background, you may not be a good custody evaluator because you may not really understand the breadth and the depth of what's needed to really come to the right conclusions in cases. So, I'm going to read to you a case example, a case vignette. Dr. Lewin is a clinical and forensic psychologist who was court-appointed to conduct a custody evaluation for the Smith family, mother, father, and their 2 children. Mother and father have been separated for 6 months, and both children are severely alienated from their father. Dr. Lewin's evaluation, a custody evaluation now, consisted of interviews and psychological testing of both parents, interviews with both children, extensive review of emails and text messages between the family members, and observations of each child with each parent during an interview process. Dr. Lewin produced a written report that contained his findings, conclusions, and recommendations. Dr. Lewin testified at trial that both children were severely alienated from their father due to their mother's intense and persistent alienating behaviors. He recommended that the children's father should have custody of them and that co-parenting would not be successful. So that's an example of a custody evaluation where the evaluator came to a conclusion, stated it clearly, made clear recommendations that were consistent with the conclusions. Because I think we've all probably seen custody evaluations where the conclusions don't match the recommendations. And you're left scratching your head like, I don't understand this. And if you're confused, then the judge is going to be confused. The whole process is going to be confused. So that's a custody evaluation. 2 more points. One is that custody evaluations are not always ordered by judges. You can file the motion, you can ask for it, but oftentimes they don't file the order. They don't go with it for a variety of reasons. The attorneys might object to it. They might not be able to agree on who the evaluator is going to be. They claim that they don't have the finances to do the custody evaluation. The children are too young. There's a whole host of excuses that people will come up with, and judges will go with it. So it's not a fait accompli that a custody evaluation is going to be ordered by the judge. In fact, more often than not, it's not, in my experience, especially lately. The second one is that if a judge does not order a custody evaluation, there is 0 chance that both parents are going to agree to it voluntarily. It's just not going to happen because one of the parents and one of the parents' attorneys are going to object to it. They're going to think it's not in their client's best interest to do it, and so it's not going to happen. So custody evaluations almost always, 99.9% of the time, have to be ordered by the judge, or it's just not going to happen on their own. Okay, next. Blind testimony. So when PA has been raised in a case by one of the attorneys, the judge may decide that they need a mental health expert to come in to explain to the court, what is this parental alienation I'm hearing about, and help me understand it. So a judge will appoint a blind expert to come into court to talk about what PA is in general. And that's where you go through all the stuff we talked about before. The basic definitions, alienating behaviors, the 8 characteristics of an alienated child, different levels of severity, all the things that we had on the earlier slide. Blind consultants are not usually attacked for being a hired gun because the court is asking you to come in. And so being an expert in the court in a blind kind of way usually protects you from massive attacks by the other side. So when you testify at trial as a blind consultant, you're going to be focusing on the general principles of parental alienation. Now, one way to expand that is that attorneys can ask you hypothetical questions that will help bring in the facts of the case without bringing in the facts of the case, and will begin to connect the dots in a specific case, even as a blind consultant, even as a blind expert. And again, the primary goal is to educate and inform the court about parental alienation as a blind consultant. The roadblocks is that sometimes you'll have opposing counsel who will object to the testimony on the grounds that it has no relevance to the case. And the judge will usually dismiss that because they essentially want you there to inform them, to educate them. And so that usually is not a roadblock that wins. Testimony is limited by the fact that it's blind, and you usually do not delve into the facts of the case. But again, if it's done well, hypothetical questions can be a great way to begin to connect the dots about a specific case, even with a blind expert. If they're not good hypothetical questions, sometimes it can be a distraction. So, Dr. Burns is a child and forensic psychiatrist. He was court appointed to provide expert testimony on the general characteristics of PA and families, essentially as a blind expert. Dr. Burns discussed definitions, the list of 17 alienating behaviors, the 8 characteristics of an alienated child, the 5-factor model of diagnosis, the levels of severity, treatment programs, and more. The rejected parent's attorney then asked Dr. Burns a series of hypothetical questions that tapped into the facts of the case in question. Dr. Burns was allowed to address these questions and was able to connect the dots to the facts from a PA perspective. Number 3, being retained as a consultant by the rejected parent's attorney to help that attorney behind the scenes. In other words, there's no anticipation that you as an expert are going to testify in court, but you are going to be brought into the team, brought into the case in order to educate that attorney and help navigate the case for the attorney so that attorney can do a good job in the case. So instead of informing and in educating and guiding the judge in that scenario, you're essentially educating and informing and guiding the attorney who has brought you in to help navigate the case on their end, okay? So Dr. Wilson is a clinical and forensic psychologist who was retained by Jeff's attorney. Jeff is the rejected parent in a PA situation. His ex-wife, Sarah, has alienated their 2 children from their father. Jeff has filed a motion for primary custody of his children on the basis of severe PA at the hands of their mother. Dr. Wilson has been involved in this case for months. He has educated Jeff's attorney about PA, the 17 alienating behaviors of an alienating parent, the 8 characteristics of an alienated child, and the 5-factor model of diagnosis. She has provided advice about motions, questions for depositions, strategy, and questions for trial witnesses. She has organized the facts of the case into a PA framework that is compelling. She has prepared the attorney for the common criticisms of PA. At trial, Dr. Wilson did not testify, but instead helped the attorney dissect and reframe the conclusions and recommendations of the custody evaluation, which they deemed to be inaccurate and unhelpful. The attorney had already decided that Dr. Wilson would not testify at trial, and that all of the effort would be done in preparation of trial. The fourth way is that the expert is retained by the rejected parent in concert with the rejected parent's attorney with the plan of bringing you in as in testimony at trial. Okay. So rejected parents will often reach out to experts because they are frustrated and scared and confused, and they really feel the stalemated strangulation of the PA process in their particular case. And so rejected parents will reach out to experts to see if they can find somebody who is able to come on board to help essentially litigate their case in a way that this judge will understand what PA is. So what an expert in that particular situation will do is they will look at really essentially all of the same information that a custody evaluator would look at. They will look at a timeline of events. They will look at all the documentation that the rejected parent can provide them. Pleadings, recordings, text messages, emails, whatever it is. You will look at that stuff and begin to put it together and organize it in a way that makes sense and can make sense in the case. Dr. Marks is a child and forensic psychiatrist who is retained by Nancy, a rejected parent. Nancy's 3 children have been moderately alienated from her for 9 months. Dr. Marks was retained to testify at trial. Her task was to prepare testimony that would address general PA principles and synthesize the facts of the case into a compelling narrative. Treatment options and critics' misinformation would be addressed, offering a clear diagnosis, if it applies, should be avoided since one parent and the children have not been interviewed. So there are limitations to your role as an expert in that situation because almost always you don't have access to the alienating parent. Sometimes you can have access to the children, but not always and not usually. So in this particular case that I'm referring to, Dr. Marks was able to refer to pleadings and emails and recordings and all the documentation that was provided in her testimony and was able to make clear conclusions and recommendations based on the general frameworks of PA plus the facts of the case as understood. So let me kind of end, because we're running out of time, but I want to say this, and this is one of my big deals, is that I think experts should be advocates. They have to be advocates. And what I mean by advocates is nobody is going to tell the clinical truth unless you do it. You're the expert. You know your stuff. And you have to be an advocate, and you have to tell the truth, and you have to say it clearly and firmly. Because I run into people all the time, whether they're experts or GALs, they're always talking about being neutral. Well, parental alienation needs something way beyond neutrality. If it's there, you need to be an advocate for it, and you need to tell the clinical truth about it as clearly and as firmly as you can. If it's not there, you don't say it. So I'm not talking about manufacturing things or making up things. I'm talking about being objective doesn't mean you can't be an advocate. So neutrality is a bad word in my vocabulary. I don't think you should ever be neutral. You should take a stand. And if the stand is this is parental alienation, you need to say it, defend it, be cross-examined about it, but be firm about it and be clear about it, and don't shy away from it, because neutrality usually leads to the status quo, and what you're really doing is enabling a situation to continue as opposed to trying to make a difference.